We're going to begin with Radhika Rao and her presentation, What is an Embryo? A Taxonomy of Human Life. Professor Rao.
Okay, shall I come over there?
Perfect.
Okay. So it is such a pleasure, and thank you again to all of the conveners, Glenn, Judy, Carter, Susanna, Laura, and all for this fabulous conference. I am hoping to actually speak less than my time. Number one, because I don't have a PowerPoint presentation. Number two, because hopefully you've all read the papers, and I really want to get feedback. So originally, when I submitted an abstract to this paper, I called it a taxonomy, what is an embryo, because I wanted to examine the where, when, why, and how, the ways in which the status of the embryo differs depending upon where it's located, why it is created, whether for reproductive purposes or for research use, when, at what stage of development, and how. But the organizers and conveners wisely requested me to narrow down the scope of my abstract because that was way too much to tackle. And so I've really focused in this piece largely upon the question of location and the ways in which what or who an embryo is seems to depend upon where it is located. So very briefly, the embryo disputes prior to Dobbs largely demonstrate that irrespective of the labels that are attached, states' courts have generally addressed IVF embryos as property subject to contractual disposition by their progenitors who possess the power to dispose of them as they choose pursuant to contracts, so long as this wouldn't violate either party's right to procreate or to not procreate, and with a bias in favor of the right not to procreate. And to some extent, I think that this understanding may have stemmed from a misconception of the abortion cases. I very much agree with Glenn Cohen's argument that the prior precedent doesn't protect a naked right not to be a genetic parent when genetic parenthood is unbundled from gestational and legal parenthood. So really, it was about a right not to be a gestational parent. But Dobbs has essentially clarified that misunderstanding by eliminating the right not to procreate. And so even though I think that laws that would have protected embryos as people prior to implantation, like Louisiana's longstanding law, probably were constitutional prior to Dobbs, I think it's quite clear with Dobbs and the elimination of the right that was protected in Roe and Casey, that laws that would protect embryos, extracorporeal embryos as persons, now should be deemed constitutional. But that brings us to the IVF exception. Many states have explicitly created carve-outs for IVF. And some states have, even though they haven't explicitly, implicitly seem to be addressing extracorporeal embryos so differently from embryos that are inside the body. Which brings us to the question of this contradiction in the status of embryos. If in vivo embryos are protected as persons from the moment of conception, pursuant to state abortion law, can in vitro embryos still be treated as property? Not many courts have grappled with this, nor have many states explicitly confronted the question, but one court in Texas actually did kind of grapple with the question when a husband and wife went through an IVF embryo dispute. Prior to Dobbs, the court awarded the embryos as per the couple's agreement, but shortly, and you know, the IVF occurred prior to Dobbs. The trial court ruling that treated embryos as property subject to contractual requirements between the parties was issued a few days after Dobbs. 1 month later, the wife petitioned for reconsideration pursuant to a Texas abortion ban that had been triggered by Dobbs. And the Texas Court of Appeals ruled that even though the Texas statute, the abortion statute, defined an unborn child as an individual living member of the Homo sapiens species from fertilization until birth, including the entire embryonic and fetal stages of development, and a statutory definition that would appear to encompass extracorporeal embryos, the court ruled that this definition, because it was found in a law regulating abortion, presumed pregnancy. So the statutory protection for unborn life was confined to entities located within the female's body during the entire stage of development. And location was also the focus of a formal opinion that was issued by the Tennessee Attorney General, Skrmetti, in the wake of Dobbs. Tennessee Attorney General Skrmetti explicitly clarified the status of IVF embryos based upon where they are located, saying disposing of an embryo that has been created outside a woman's body and that has never been transferred to a woman's body does not qualify as an abortion. Such an embryo may fit the Tennessee law's definition of unborn child, but the act doesn't prohibit the embryo's disposal unless and until it is living within a woman's body. So what does this mean? It seems as if the line between embryos that are regarded as persons and those deemed property is quite often drawn based upon where the embryo is located, whether inside or outside a person's body. Embryos gestated within a womb may be afforded some of the protections that are accorded to persons, whereas embryos cryogenically preserved in a lab are often handled as property. And I think you can see this in terms of if we think about property as a bundle of rights. One of the key sticks is the right to destroy. And essentially, under current law, state law, most states seem to handle IVF embryos as property that is subject to destruction by their owners, the progenitors, if you think about the right to destroy being a key stick in the bundle. And another key stick in the bundle of rights that we conceptualize as property is the right to sell. I think that's very foundational to the idea of property. But a lot of law, federal law, bans the sale of embryonic and fetal tissue only if it's been within a person's body. So embryos that were never part of a pregnancy, currently under current law, could arguably be bought and sale. And in fact, there are fertility clinics, including one quite prominently in California, whose business model is to offer embryos that are made for sale, mass-produced by purchasing sperm and eggs and then creating the embryos to be sold at reduced cost to parents seeking a child. So if what an embryo is depends upon where it's located, LePage describes location as, quote, an ancillary characteristic. And a very, this is very reminiscent of a trial court ruling in Cass v. Cass, which reasoned that the legal status of the embryo shouldn't rest upon its location because location is mere situs, not substance. It's kind of accidental. But in this paper, I argue that location is not an ancillary characteristic, that an embryo inside a womb is not merely an astronaut inside a uterine spaceship, is kind of the analogy drawn by philosopher Kingma, contained within but separate from the pregnant person's body. But to the contrary, it's a part of the pregnant person, biologically connected and integrated into her body, more akin to a body part or an organ rather than an independent organism. And this is building upon a wonderful paper by Greer Donnelly, conceptualizing a fetus as a property of the pregnant woman. So paradoxically, I think an embryo within a pregnant person's body more closely resembles property and shouldn't be conceptualized as a person, because to do so would treat the pregnant person as a container for another, effectively form of property. Conversely, in vitro embryos that exist outside a body are currently treated as property, over which the progenitors possess many of the paradigmatic sticks in the bundle, including the distinctive power to alienate and destroy. But these extracorporeal embryos could be characterized as persons without infringing upon the personhood of another. So our current person-property dichotomy is completely topsy-turvy, upside down, and that perhaps we should reconceptualize or at least question this dichotomy and ask, to the extent to which embryos are being treated instrumentally as property in some contexts and persons in others, what values and justifications provide a rationale for the current status, and shouldn't it be the other way? And I think my time's up.
Thank you very much for your,
So I said I was going to be
yeah, no, it's
short,
perfect. You got to.
and I went for the full time.
Well done. Next up, John Evans. Professor Evans.
Okay, thanks. It's great to be here. I'm going to do this old school. This is like what I used to write in chalk on the side of the chalkboard with my outline, except where you see orange, it's where I am, in case you doze off. So I'm a sociologist and bioethicist. What I mostly do is I contribute to bioethical debates through participating in bioethical debates like the room here in front of you, and then operationalize those through social science to try to contribute. So everything you say may be operationalized into a research instrument. In my political theory of bioethics, we should be using the public's values, not necessarily the conclusions, but the values to suggest ethical policy to the government. So that's largely what I'm engaged in doing. So we need to ask the public about these embryo models, using the public's assumptions, not the assumptions of scientists and ethicists. So, the main difference in assumption between bioethicists, scientists, and the public is in anthropology. Anthropology means the definition of the human. I conducted a study about 10 years ago now, and I found that the dominant anthropologies used in the US public are the biological and the Christian theological. The biological, a human is that which is born from another human or looks like a human. I recognize that's tautological. In the Christian theological perspective, humans are those made in the image of God, which I'll get into briefly. These are mixes of ontology, what a human is, and moral status, how the entity should be treated. Now, on the other hand, bioethicists and scientists use what I call the philosophical anthropology, which is concerned not with ontology, but with moral status. For ontology, the philosophical relies upon academic biologists' definitions of life forms. The moral status, the anthropology says that the entity would be a person, hence the term personhood, if they have certain capacities. So using this anthropology, a human embryo would not have human status because it lacks important capacities like consciousness. For the philosophical anthropology, the ontological form is not relevant to moral status. So famously, people have argued for chimpanzees having personhood, or dolphins, or even AI. Therefore, the primary, or perhaps the only ethical issue in bioethics for whether an embryo model has the capacities required for personhood. So, for example, the Nuffield Council in Britain says they would be concerned if an embryo model had, quote, the capacity for pain or awareness. Several prominent bioethicists say in an article that no embryo model should ever obtain the capacity for sentience. Since natural human embryos in dishes lack these important capacities, so will embryo models, and neither would obtain personhood. As it was pointed out earlier, the whole point of creating these entities is that they wouldn't obtain personhood. So, I believe that the public will conclude, using its anthropologies, that at least an embryo model in a dish will never be human and will never have human status. The public version of the biological anthropology is based upon having human parents and a recognizable human body. Neither of those would be the case for an embryo model. To turn to the Christian theological anthropology used by the public, not the one among academics, a human is one who's created by God in the image of God with the ability to communicate with God and with other humans. The communication device is called a soul, which is implanted by God. Humans are the offspring of male and female humans going back to the first humans, with the ensoulment for Christian conservatives generally occurring when the sperm meets egg, and with liberals more like at birth. Would an embryo model be made in the image? Making a generalization across all Christianity, and sociologists love to make sweeping generalizations, I'm going to say no. For the public, the image is at least partly based on there being a moment where God creates an individual and installs a soul. But there's no moment of, for example, sperm hitting an egg, and birth is not so far planned to happen. But secondly, in the public's mind, a human is made by God or by a God-designed process, like evolution. Entities that are designed and built by humans, like embryo models, would then not be made by God or by a God-designed process, and thus are not in the image. This is a reference to something in Paul's paper we'll hear later on today. They are an artifact. So, while bioethicists use their anthropology to establish that embryo models lack personhood and thus moral status, I think that embryo models do not even register for the anthropologies used by the public. If anything, they're more controversial in the bioethicist anthropology than the predominant anthropology of the public. For the public, all but embryo models that become actual babies would be non-human. Now, but I should add, that doesn't mean that they aren't going to be controversial. What would that controversy be, if not anthropology? So, medical sociology and anthropology repeatedly finds that a good portion of the public believes that adults retain an ephemeral connection to their disembodied tissue. A study of the public's view of blood found that many thought the blood was still theirs after donation and saw the relation to blood as parental, saying things like, "It's like my children. They may grow up and be their own person, but they're still my child." The public may see a connection between a cell donor and the embryonic model as akin to parent and child, with that connection influencing the opinion and the ethics of creating embryo models. The strong version of ephemeral connections is almost communicative, suggesting that the soul of the person is still connected to its parts. So for some people in the blood donor study, blood was a, quote, bearer of personality or moral disposition, unquote, that would be transmitted to the recipient. Similarly, in a study of tissue specimen donation, the authors found that some people resisted because, quote, biospecimens are an extension of the self and require special care and respect. For those who talk this way, the physical nature of biospecimens retains an individual's essence. As one respondent said, "I feel more uncomfortable with giving a biological specimen because it feels like an attachment or extension of myself." The strongest ephemeral connection is the perceived transferal of the self of the dead person via transplanted organs. This has been found in so many anthropological studies, it's just a truism in medical anthropology. Also consider what is probably the most famous case in all of bioethics, Henrietta Lacks. She was a poor African-American woman whose cells were taken in the 1950s without her consent and replicated. They were sold on the basis of the HeLa cell line used for biomedical research. Now, for a materialist, what is most offensive is that she owned those body parts and did not consent for them to be used. But if you read the book describing the case, the family are decidedly non-materialist, and I think they read it like the public. The problem is the ephemeral connection of Lax to the frozen cells. The book describes scenes where Lax's children are shown a freezer full of HeLa cells, and one of the children says, quote, "I can't believe all of that's my mother," close quote. Later handed a vial of frozen cells, she says, "She's cold." Another scene, the daughter looking through the microscope says, "That's my mother, no one seems to get that." So Lax's family are not materialists and believe in a host of ephemeral connections between their mother and disembodied tissue. The public is very much like this. Finally, a few years ago, I conducted a study of what the public thought of another entity grown from adult stem cells, human brain organoids, which are 4-millimeter pieces of human brain kept in a dish. They're very analogous to embryonic models, as they're disembodied human tissue. After describing the organoid, I asked a nationally representative sample of Americans whether, quote, human brain organoids should be thought of as an extension of the person who donated the skin cells used to make it. Only 13% strongly disagreed. 15% somewhat disagreed. A majority agreed. I also asked the respondent to evaluate the strong ephemeral connection. If a human brain organoid could think, it might have the thoughts of the person who donated the skin cells, which is obviously outrageous and outlandish from a scientific perspective. But if you don't know anything about the technology, your first assumption is, sure, indeed, only 12% of the public strongly disagreed and 15% somewhat disagreed. The majority agreed. So, while I'm sure the public could be talked out of these views, okay, the initial assumption is this. This reveals the base assumption of humans to their disembodied tissue. So the punchline is that it's likely that people will think embryonic models will retain some ephemeral connection to the donor of the stem cells. This is unlikely to generate vociferous objections. There is no one who's going to say that has the same status as a baby, et cetera. But we will produce a form of discomfort or unease. Scientists and supporters who think that the lack of capacities of an embryonic model will diffuse all controversy are likely wrong. I'm currently designing, in my final 15 seconds, I'm designing a social science project to evaluate the public views of all of these humans' life at the margin sorts of questions, and I hope to get more detail than what I've talked about here about what the concerns about these technologies actually are. Thank you very much.
Well done. 5 seconds to spare. Christine, please. Professor Coughlin.
That's really interesting.
Okay, good morning, or should I say good afternoon. Thank you all for being here and for the amazing body of work everybody has produced here. I know we have thoroughly enjoyed reading it. I want to first acknowledge my co-author, Nancy King. I'm grateful for our longstanding collaboration, your consistently brilliant insights, and our friendship, which I value deeply. So we heard earlier from Susan about Goldilocks, and now you're going to hear about the little red hen and wonder what this has to do with embryos. So we do want to take you back to your childhood, and many of you may remember this story. The little red hen found some seed, planted wheat, watered and harvested it, took it to the mill to be ground, made the dough, and baked the bread. At every step, she asked for help. At every step, no one would help her. The cow, the pig, the cat, the mouse all said, "Not I." But when the bread was done and she asked, "Who will help me eat it?" everybody volunteered. Kind of sounds like my law faculty sometimes. But in the story, the hen ate it all herself. So at its essence, this story is about benefits and burdens. But this is the exact outcome we wish to avoid, right? Science is meant to be shared. We want to encourage ethical research, not stifle it. We want to promote public engagement. We want to promote responsible regulation. And we want to allow research to advance carefully and deliberately with appropriate guardrails. This will, as Vincent said before, help with innovation. And it can save and improve lives, and that's a net good for all of us. So, as you all know, embryological research is aimed at understanding more about the normal and abnormal development of embryos and fetuses in the uterus. Now, statistics do vary, but it's estimated about 30% or more of pregnancies end in miscarriage. About 3 to 4% of babies are born with genetic anomalies, and IVF has a success rate of about approximately 40%. Embryological research has shown promise in treating infertility, miscarriage, and birth anomalies. But there's more. There's indications it may also help with complex diseases such as cancer and Alzheimer's. But this research has long faced significant challenges because of the moral quandaries that we've been discussing today. And that tension between moral and research has resulted in things like the 14-day rule, which is now being considered to be expanded to maybe 21 or 28 days to help unlock some of these mysteries. So, like Dob and Mary, we did start with history, and we tried to briefly trace U.S. history, and we end where we are today. So we look more closely at NIH funding, in which human embryo research has basically ceased and human fetal tissue research defunded. And we recognize that NIH policy is preferring embryo models at this point. But that's not the whole story, right? Because with regulation in this area, we have to look at federal law and state law, and that's where Dobbs comes in. So in 2022, after Dobbs, many states amended, expanded, or reapplied existing statutes regarding fetal personhood. And they treated, a lot of the times, they treated these as crimes perpetrated against the fetus. Now, depending on how they're counted, and there's a variety of ways to look at these, there's between 17 and 44 fetal personhood states. And then we've talked a lot about the Alabama case and LePage that held in 2024 that frozen human embryos are extrauterine children, and the result of SB 159. When we look at embryonic personhood states, again, depending on how they're counted, there may be as many as 14. Embryonic personhood bills or the states, where broadly defined, could conceivably implicate some embryonic research. Now, there's also states that define and look at embryonic research specifically. 11 have effectively banned this research. Others do expressly allow it. Our concern that we talk about in the paper is one of risk. And we are concerned that scientists, research institutions, and funders are concerned about the risk of doing this type of research in states where it is not clear, whether there's a carve-out or not. So as a result, a while ago, we have started looking at some alternative models. Each of these models has both promises and pitfalls. So non-human primate research, which was actually in the news yesterday with the new NIH guidance, they're usually poor proxies for humans. The findings rarely constitute a good faith basis to launch a clinical trial. And if we talk about human research with primates, they're too close genetically to humans to have extensive research use and that be ethical. Organoid arrays and digital modeling, body-on-a-chip arrays of linked cell-based organ models do emulate interaction among tissues and do enable testing. This could help streamline but not replace human testing. Rapid advances in AI have spurred the creation of digital twins. I find this so cool, right? Virtual real-time replicas. And they can be instrumental in creating new clinical models, but we don't know how they will fare. It's just too soon to tell. And then third, non-human and chimeric embryoids. In addition to a concern about mixing species, human and non-human embryos do grow at different rates, so the milestones that matter are reached at different times. So in our paper, we talk about the emerging winner, these embryo models. They mimic embryos, but they're not embryos. So they can open the door potentially to do research for a longer period of time without the need for IVF donors or other embryo sources. Wait a minute, sorry. But the ethical issues posed by embryo models are familiar. How well do they model human development? How far should they permit it to develop? Is there a tipping point? Are there taboo milestones? And if so, when do we reach them? So as we heard about last night with Jacob Hanna's work, and as we've even talked about today, at some point we're going to question whether these human and embryos and embryo models may be too close to call with respect to research. So here is where we come into what we think is the little red hen metaphor hits the hardest. If the goal of embryonic personhood is protecting and promoting the health of pregnant people, fetuses, and embryos, then in addition to research combating miscarriages, infertility, and congenital anomalies, we also need to make sure that we're providing basic structural support. We need to employ the evidence-based standards that we know will work, such as making prenatal care affordable and accessible for all. We need to make sure that people have safe housing and jobs that pay a living wage. We need to eliminate food deserts and provide for affordable medical and preventative care. And unfortunately, some of the same legislatures that are advancing these broad embryonic personhood laws are the same legislatures that are cutting or limiting social supports. So in the context of the little red hen, they're not only not helping to make the food, but in many ways they are preventing it from being grown in the first place. With respect to embryonic personhood, the bottom line is that some states may choose to disallow embryo-based research. And those same states may choose to allow or prohibit embryo model research. But in the end, all are going to want to share in the benefits. And sharing results is, of course, a basic tenet of science. But what about access to those benefits? In embryonic personhood jurisdictions, and indeed in many more, many members of our communities, particularly those with low incomes or members of minoritized populations, will lack more than just access to social supports. They will also be unable to gain access or afford the services and treatments that have been developed using embryo models. According to a 2025 study by Katie Watson, I believe it's 81% of fertility patients have household incomes of more than $100,000, and 75% of those patients were white. So to take this a bit further, the wealthy can afford IVF, the wealthy can travel to other jurisdictions, or, as I'm so excited to hear about later, outer space, and they can pay for expensive treatments that depend on basic research into human development. And this is a fact that Katie talks about earlier, and that I want to reiterate, that the need for a different model to look at this and to look at all of this. This week's SpaceX IPO was again a stark reminder of the real economic gap here in America. As the gap between the privileged and the disadvantaged grows, the unique intersection of embryonic personhood and medical research widens that gap into a gulf. So while research with any type of embryo equivalent is important and hopefully supported with appropriate guardrails, the resulting knowledge should be applied through equitable policies and affordable treatments. The sharing community of scientists cannot make up for the lack of caring by political actors. So, in closing, the little red hen's lesson to her barnyard animals is that benefits and burdens are related. Science is meant to be shared. It should involve robust public engagement, responsible regulation, a careful and deliberative process, appropriate guardrails, and equity in distribution. Without this recognition, we remain in an increasingly Orwellian society in another barnyard, one that where all the animals are equal, but some are more equal than others.
Thank you very much. And finally, Professor Beckwith.
Thank you so much. It's wonderful to be here. My title of my paper is Equal Dignity, Embryos, Moral Status, and the Law. When I looked at the other names on the docket, I thought to myself, if this were the Beatles, I'd be Ringo. And I'm just wondering, I'm just glad to be in the band, in other words, but thank you for having me. There are two contending traditions within the broad contours of what we call liberalism, the political philosophy that gave form to our modern understandings of rights, fairness, equality, and justice. The first one I call the autonomous tradition. Its champions have libertine reflexes, putting a premium on personal autonomy and independence, expressive individualism, procedural justice, consent as the sole basis for particular obligations, state neutrality on the nature of the citizen's chosen vision of the good life, and understanding community as more cooperative than constitutive. The second tradition I call equal dignity. It is marked by a more inclusive and caring ethos, emphasizing human equality as an unchanging essential property of our nature, the givenness of our dependence on one another along a ragged continuum from cradle to grave, rejecting ableism, securing natural duties, and understanding community as more constitutive than cooperative. I want to argue in the paper that we should err on the side of equal dignity when it comes to the question of the embryo and its nature and its relation to law. Now, in the late 60s and early 70s, when the issue of the moral permissibility of abortion was being debated, certain philosophers and theologians began developing arguments in order to establish a distinction between human persons and human non-persons. Now, once that distinction was secured, it allowed advocates to conclude that prenatal human beings, including embryos, lacked moral status. Marianne Warren, for example, asks us to imagine how we would determine whether members of a spacefaring alien race had moral status. She argues that we would recognize their moral status if they exhibit certain characteristics that we typically attribute to persons, such as consciousness, reasoning, self-motivated activity, the capacity to communicate, the presence of self-concepts and self-awareness, and so forth. Michael Tooley, arguing along similar lines, appeals to the understanding that if an individual it has moral status only if it possesses the concept of a self as a continuing subject of experiences and other mental states, and believes that it is itself such a continuing entity. Warren and Tooley's criteria accentuate the condition implied by the autonomous tradition: self-expression, self-reflection, rational deliberation, autonomy. Although this reasoning dominates the bioethics literature, it was proposed within the context of the debate about abortion. Legislators and regulators that want to explore the issue of the embryo and some of the research having to do with IVF and so forth weren't saddled by the conflict of interest that is predominant in Roe v. Wade. What resulted with subsequent government commissions dealing with bioethical issues was a sober acknowledgement that prenatal life had intrinsic worth, that it entitled it to a respect not accorded to other non-human research subjects or organic materials. Although for most commentators and government commissions, this special recognition frequently fell short of full personhood, it exhibited the reflexes informed by equal dignity. For example, in the 1994 NIH panel on human embryo research, it states that it recognizes, quote, that the embryo merits a respect as a developing form of life and should be used in research only for the most serious and compelling reasons, unquote. Deployed to justify certain forms of research, artificial reproduction, or therapy, the general sense of these reports is that the embryo's moral status should be assessed with criteria more closely aligned to the autonomous tradition. So, for example, in the same report, the panel notes that the early embryo, quote, lacks even the possibility of sentience as well as other qualities. It does not have the same, and for that reason, does not have the same moral status as an infant or a child. Now, what I want to suggest is that there's several reasons why we should err on the side of equal dignity. So I'm going to go over a couple of them and look forward to hearing some questions. First, I think the equal dignity approach best accounts for the moral status of the postnatal cognitively disabled. Take, for example, Warren's claim that, quote, defective human beings with no appreciable mental capacity are not and presumably will never be people. And a fetus or an embryo is a human being which is not yet a person and which therefore cannot coherently be said to have full moral right, unquote. But this strikes people today as kind of a textbook case of ableism. Equal dignity, it seems to me, better accounts for this wrong, for it sees personhood as a way of being, not a way of doing. And thus the cognitively disabled do not lose their dignity as persons simply because of illness or calamity preventing them from exercising the proper accidents that flow from their essential nature. This account of personhood is capacious enough to include embryos, since it conceptualizes a human being's maturation and development as merely the unfolding of a nature that it possesses from the moment it comes into being. Thus, a human being that lacks a good because of a congenital disability, old age, accident, disease, or immaturity is still an organism of a rational nature. Secondly, it accounts for human equality without appealing to degreed properties. The attributes that the autonomous tradition considers decisive come in degrees: reasoning, self-consciousness, capacity to communicate, awareness of a continuing self, and so forth. But this seems to be in tension with our egalitarian intuitions, since human beings possess these properties across a continuum and are constantly in flux. This is why Jeff McMahon, a philosopher within the autonomous tradition, laments, quote, "All this leaves me profoundly uncomfortable. It seems virtually unthinkable to abandon our egalitarian commitments. It is hard to avoid the sense that our egalitarian commitments rest on distressingly insecure foundations," unquote. As in the case of the moral status of the cognitively disabled, equal dignity offers a more parsimonious solution to reconciling our commitment to human equality with our cognitive diversity. Each and every one of us is equally an organism of a rational nature, regardless of where we exist on the continuum of human life or how well we exercise our abilities and powers. Third, the equal dignity accounts for the wrongness of intentionally creating disabled embryos for organ harvesting. In a 1997 paper on the morality of human cloning commissioned by the National Bioethics Advisory Commission, philosopher Dan Brock suggested the possibility of using cloning technology to create brainless human embryos for the purpose of harvesting their organs after they develop into fetuses. He actually relies on an article by Carol Kahn, which had been published in the 1970s. Now, to grasp Brock's point, consider the fictional case of a future biotech company that manufactures transplant organs by modifying the cognitive development of an IVF-created presentient embryo. The company's scientists prevent the embryos from acquiring higher brain functions so that they may never achieve any of the characteristics that the autonomy tradition claims give a being moral status. These embryos otherwise develop normally. Their organs are then harvested so that they may be sold to the company's clients. Now, suppose that equal dignity radicals break into the company's labs, abduct all of the post-tinkered with embryos and transport them to a secret lab beneath St. Peter's Basilica, where equal dignity scientists reverse the damage that has been done to the embryos so that their development trajectory is restored. Did the equal dignity radicals engage in an act of justice and help the embryos return to a state of health and flourishing appropriate for organisms of a rational nature? If one answers yes, then it seems reasonable to suggest that it is a prima facie injustice to intentionally engineer embryos so that they never actualize any of the proper accidents to which their essential nature is ordered. I have one more. I think I'm...
Yeah, one minute.
One minute, so I've got to skip my last point. So let me just wrap this up. Proponents of the equal dignity tradition counsel caution toward any theory of moral status that would exclude a class of human beings from legal protection on the grounds that such exclusion serves the advancement of scientific knowledge, the securing of market demands, or the interest of another class. Drawn upon the historical record of societies that have constructed hierarchical accounts of personhood, the equal dignity advocate argues that it is unlikely that we are the first generation to offer a philosophically justified two-tier account of human moral status. Thank you.
Okay. So before we begin with questions, I'm going to ask Susanna, how long are we going? And Glenn? 12 minutes, great. So I think we should follow the model, and we'll go around and take a bunch of questions and then give the panelists a brief response. But I'm going to usurp that role in an authoritarian fashion just by making two quick comments. The moderator's privilege, which I will wield as a dictator. Quick comments for Radhika. One thing that might be interesting to look at is the America Invents Act and the banning of patenting of embryos, which codified the Weldon Amendment, which existed as an appropriations rider for years. It's a fascinating encumbrance on the property rights, or if you will, of people who have dominion over in vitro embryos. Second, short comment to John. Antonio Regalado yesterday talked about the work of Jacob Hanna and talked about the wide array of different kinds of stem cell-based embryo models and how ISSCR has abandoned this notion of integrated versus non-integrated, I think for good reason. But there are many different kinds of embryo models, or so-called synthetic embryos, and the idea of a 70-day embryo, which Jacob has talked about wanting to cultivate in his sort of ectogenic rotating bottle, having, as Antonio said, hands and feet and a face. And if you look at the literature of Magdalena Zernicka-Getz and Hanna himself, what they describe as heartbeats and brain folds, how does that affect the public's understanding of what it is that we're doing? And this connects to the line drawing that Professor Coughlin asked. Okay, so let's start this way, and we'll go around the opposite direction. We're going to take short questions, and then we'll give an opportunity for our panelists to respond. So we'll start with Ben.
Thanks. Thanks for the great panel. So my question is sort of focused on Radhika, but it spills out into the rest of the group. So the one place that you don't talk about as a contingent place in your presentation is the courts themselves. So the US is bizarre and unique in the sense that all of these questions got asked in relation to actual, real, living cases in the idioms that were available to judges, basically, that the law provides. So it's sort of not surprising maybe that person's property is the sort of dualism that's available, and given how anomalous that is in relation to other societies' sort of moral vocabularies deployed to contend with these things, it seems to me that I mean, that's just a very important element of the picture. And it seems, so then it becomes a question of, I mean, is this sort of a case of runaway law, in effect, like law seeking to elaborate things that are beyond its capacity to elaborate, or the production of a disjunction between the forms of understanding that John was presenting and the repertoire available to the court. So that's my version of the question to John. And Christine, it seems to me that Christine and Nancy, it seems to me that your presentation actually has a, place matters dimension to it very much as well, because of the way in which public and private are encoded into regimes that privatize in the name of public benefit. So, I mean, you could substitute whatever, gene therapy or something like that as a serious problem that fits the profile that you're describing in terms of distributive justice, except that the idea is that the machineries of innovation in which you have enormous disparity are themselves the machineries of distributive justice. So encoded into a different structure is a corollary set of, of constructions of what the good is. And so the question then is, should we be asking the question, what is the good, as opposed to, is it person or property?
Okay, Emma.
Thank you for an excellent panel. So playing off of Radhika and Christine, and really a number of comments, I wanted to introduce the issue of surrogacy, and in particular, contractual commercial surrogacy, because that's where I think you see an interesting line between the embryo as potential person, the embryo as property, the woman as person with reproductive autonomy, such that the commercial surrogate has complete rights over what occurs to the child while it's inside of her, and yet legally speaking loses all rights the moment the child is outside of her. And yet the majority of surrogacy contracts have a reduction of fetus clause, that there have been many court cases where parents have tried to enforce an abortion where the surrogate doesn't want one. And the complicating factors just continue from there. So I would just be curious to hear your thoughts on how you navigate the property and personhood dynamic when you're bringing in contracts that also govern adult women who are now a part of it in complicated ways. Does that make sense?
Great. So anybody between Dove and Emma? Okay, Dove.
Thanks. For Nancy and Christine, your hypocrisy framing seems to presume that personhood jurisdictions intend to use the embryo research-derived treatments, and I wondered, is there evidence that they do? For John, you suggest that theological anthropology leaves stem cell-based embryo models in a kind of conceptual limbo because they lack an ensoulment moment. Yet pro-life movements have historically extended personhood claims to new technological entities pretty quickly. Take IVF embryos. So I'm wondering if I could ask you to put on the hat, kind of SCBEMs Stradamus here, and ask you what predicts whether religious authorities or activists will assimilate them into the protectable category.
Great, coming around the corner. Anybody? Okay, yes, please, Anna. Oh, Jingping, did you want to ask? Go ahead, please.
Yeah. Every time I come back to Petrie-Flom Center, I was always amazed by how interdisciplinary this community is. So it's really pleasant to be part of it. And my question is for John. John, you briefly mentioned the public survey project you will be doing, if I understand it right. So I was wondering, many people discuss about how different the country's perspective can be different on the stem cell models or other models. So I was wondering, is this project comparative, or will you just compare across states, etc.? And I also want to understand, how do you think this project will benefit policymaking? Yeah.
Great. Anna.
Thank you so much for the interesting panel. I had a question for Professor Beckwith. Thank you for the interesting talk. I heard you mention that, personhood in this sense is considered a way of being, not of doing. So an ontological claim, essentially. And I was curious about your thoughts on this response in the literature that for this ontological argument to apply, there is at least a minimal criterion that should be met, namely that the embryo should be numerically identical to the later human being that emerges from it. I was curious to what extent, if any, you think this would matter for an equal dignity perspective, and if you think it does, at what stage you would consider the onset of such a numerical identity and therefore personhood. Thank you.
Yeah, thank you. Yeah.
Okay, anybody between Anna and Maureen? Okay, Maureen. There you go.
Yeah, so I was directing my question towards Dr. Evans. I'm often struck in sociological research how the answer you obtain reflects the way you ask the question. So I'm curious with respect to people who you characterize as having a theological anthropology, how would those people view the sheepness of Dolly the sheep, of a cloned organism? And if we had a cloned human who came about through a similar mechanism and was born alive and grew up and as Dolly did, how would they view that human who did not arise by anything even remotely like a natural process?
Glenn.
Boy, this was fun. I want to ask everybody, but Professor Beckwith, I want to return to your Dan Brown in the Basilica of St. Peter's hypothetical for a moment.
Dan Brock, not Dan Brown.
Well, no, I meant
Brock.
Dan Brown, like the Da Vinci Code. I meant Dan Brock, rest in peace.
It
Sounded like both.
An albino monk in that.
There we go. Here's a parallel hypothetical I've written about a little bit, which involves birds. So imagine we could take the same technology and turn a little bird into Big Bird, like from Sesame Street, so they'd have all the capacities of human beings and be able to talk. And the question was the same one about whether you think it would be an act of injustice not to do this for the little birds. And I presume one answer you might give is, well, that's not the kind of entities birds are. These are the kinds of entities that human beings are. But for somebody with a capacity view, that seems to assume the answer to the question rather than enable it. So I'm curious whether you think this intuition pump, what it says about neural chimeras for animals.
Yeah, thank you.
Okay, so wonderful questions. Let's give 1 minute to each of our panelists, and either Christine or Nancy, you can take your minute, however you want to do it, if you want to respond.
Well, I'll respond to Dove's question because it's actually the easiest of everybody else's questions. No, we don't have any empirical evidence about how an embryonic personhood state might actually treat the results of research that they deemed impermissible. But it's hard to imagine the complexity of a governance structure that would actually make it possible to even figure out what products of research should be precluded from access and how to go about that. So I don't think that's really a problem. I hope.
Thank you. John.
Okay, so in my 1 minute, I'm going to do rapid fire with these questions. Number one, is social science totally dependent on the way you ask the question? Absolutely. My whole career has been focused on solving or controlling this problem. Let me hold off on the sheepness for a second. Let me return to comparative. As a principle of my type of sociology, I don't do comparative projects unless I'm fully conversant in the culture I'm talking about. So this is a claim to the United States, conceivably the Anglophone world, but I would go no further. I have no doubt it's totally different in different countries. Then number three, let me do Dov. I think that, so the things that have been created that obtain this status up to this point have been mergers of men and women, like, IVF embryos and the like. And there haven't been ones that are sort of they're distinct from men and women, and that's what makes this moment, I think, unique. And so that's why I want to get into that. And then finally, number four, which is what Carter was talking about, which is, yes, all those things that Anthony was talking about were in my notes, and I'm going to look for all of those in this project designing. I have no doubt that if the public is shown things that look like babies, which we know this from the abortion debate, that things that look like babies generate a different response because the public's anthropology is based upon appearance. It's not the sort of deductive logic from top to bottom. That's not how the public reasons. And the public is also engaged in casuistry, not engaged in top-down reason. That's how they reason. And finally, I'll make one statement I realize I should say from listening to everybody else, which is the public are absolutely not purists about anything, okay? And so let me give you an example from human brain organoids. Even the people who want to protect human brain organoids will say, yeah, destroy them if you've got a good reason. If it's for medical research to cure Parkinson's disease, absolutely. But if you're going to grow 1 million of them, wire them together to make a biological computer, which is being proposed by the National Science Foundation, the support would go through the floor because it's not a good reason. And reducing the suffering from disease is the universal good reason in American society.
Frank.
Yeah, a couple of brief comments about first with John. I thought, I really thought your insights about how people come to believe things about the nature of the embryo and abortion and so forth, it reminds me of years ago, there was the Right to Life movement made this argument to sort of play down fetal personhood and talk about how abortion could affect the woman. And their argument was that you'd have these polls where people would come to the conclusion, they would be asked what the morality of abortion, what their views were, and they would say it's immoral, and yet they would also, at the same time, there'd be like 20% that would say it should still be legally permissible. And it made me wonder whether even the standard of personhood is the right way to sort of interpret how people answer that question. It could very well be that 20% are people that just think there's like something wrong, but it's not really wrong. Absolutely. And I think that there's that category. And then the other two papers, we both touch on Dobbs a little bit. I was wondering, years ago, back in the 25 years ago, I published an article in the Nevada Law Journal making the argument that Roe v. Wade is really about the court dealing with two conflicting interests, and that at the end of the day, states are really kind of free to legislate about embryos as much as they want, and that's for that reason, I'm not sure Dobbs would have made a difference in the Alabama case. In other words, I think the Alabama court would have come to that conclusion even if Roe v. Wade hadn't been overturned. So, yeah.
Yep, Radhika.
So.
Okay, so on the point about corpses, I actually did think about including it because I've written about corpses in an article called Property, Privacy, and the Human Body. The corpses are often treated as quasi-property for instrumental purposes to protect the interests of their relatives. And so it kind of fits, and maybe I will include it in my 5,000 words, cut other stuff out. On the commercial surrogacy point, I think that's a really interesting point. And I think that states currently, post-Dobbs, states where abortion is completely prohibited, people are making efforts not to engage in surrogacy contracts in those states because of the idea that a surrogate would have no more or rights to an abortion than anybody else. And so kind of regardless of what the contract says, but it's true that prior to Dobbs, contracts that purported to force a surrogate to have an abortion or would prevent her from having an abortion generally weren't viewed as enforceable. And I think that decision was correct. But I think the inside-outside is really an interesting question in the surrogacy context. And I think the difference is probably that it's post-birth versus embryo. So the stage, of course, matters of development too.
Please join me in thanking our panelists one more time. Thank you, guys.